I think we have some time for a debate. I would say around 20 minutes, perhaps even 30 minutes. And I hope there are questions in the audience and also among the Zoom participants. I was told that there was a Zoom participant question. I don't know whether there is any news about that. Any question in the audience? There is he's already there. Andrea, welcome. So it's one of our Italian young professors. So please raise your question.
Thank you very much, Professor Torre. And do you hear me?
Yes, please.
Okay. Thank you very much. First of all, I'd like to thank Professor Brownsword for his very suggestive and brilliant lecture. Unfortunately, I missed the final part of Professor Brownsword's lecture due to a Zoom failure, and this shows why we shouldn't trust technology too much. So I'd like to take this opportunity to discuss some topics of Professor Brownsword's jurisprudential thought, which seems to be not touched directly today, but I believe are implicit in the shift to the technological management. So, Professor, you wrote that in 2061, the art and distinction between an external and internal account will continue to hold good, just where it will be related to a rule-governed activity. Nevertheless, rule-governed activities would be overtaken by technological management, so that such distinction will lose its relevance. So we will not need more to take on the perspective to see social rule that we accept or endorse as convergent parts of behavior as standard of conduct. Now, let me think to the famous Brownsword work with Shire golf cart example. In the example provided by Professor Brownsword, the technological management, the data-driven agent, would guarantee that golf carts will be used responsibly by all members, and do it by replacing the category of illegality with that of categorical physical impossibility, since no one could use the carts improperly because the system will not allow it, making any infringements impossible. But this is my point. We can really renounce to the concept of norm as a device to interpret and detect social relation. Now let's think to a man who gets into a car and after starting the engine, he realized that engine turned off due to the car sensor had reported the presence of an high threshold alcohol level in the human exhalation. Now our driver perceives such turning off of the engine as a consequence of his conduct. And a consequence that is inputted to a certain behavior, as it is established in a previous general and abstract standard. He realized that the engine problem is not the result of a system failure, and he is right to know this because he will be capable to get his vehicle back in gear, to make it functioning again as soon as he will dispose it, or it will eliminate the alcohol level, and due to that is by eliminating the cause that make the action impossible. Now, if we were not fully aware about the internal aspect of the standard, the internal aspect of the norm, he would never be able to, one, first of all, understand how to resolve the technological engine addition. Two, he could never avoid in the future to get the same effect by avoiding to take the same behavior that have activated the data-driven agent blocking mechanism. And third, it can never distinguish between the engine failure from a technological management impossibility sanction, because the sensor may not be working properly in that case, so it may not be a correct one, but simply correct or false signal. Now, I think that the sentence, the Arten sentence, having an obligation to do X, for example, will still be a central meaning of real experience that will be necessary to still understand the meaning of being made and able to do X, to do the technological governance. But if this is the case, what will really change in the conceptual structure of the practice of law in the law 3.0? And I turn to the second point. In the technological management that we'll get in the 2061, what will be the role, what will be the place that will assign it to the constitutive rules? Now, constitutive rules notoriously are rules that make possible certain scope of action that without those rules could not even be conceived or performed. Let's think about a contract, for example. Now, in the transition from law to technological governance to technological management, how will this rule be taken into account? Will constitutive rule be excluded from such management? And if this wouldn't be the answer, as I think, because social regulation will not lose the constitutivity power, the constitutivity effect, I think law will retain much of the classical normativity, even in the law 3.0, since constitutive rules are a relevant part of the practice of law itself. Now, I would therefore like to know what Professor Brownsword thinks about it. Thank you for your brilliant lecture. Thank you.
I don't know whether the audience has understood the two questions. I think they are very interesting, actually. And I will try, if I understood them properly, I will resume them in my language. Now, we have seen that Professor Brownsword believes that, indeed, that rules might be replaced by algorithms. Now, there are two questions about that raised by our colleague. One is that is a bit similar to the objection made by Hart to the sanction theory. You might remember, if you read Herbert Hart, The Concept of Law, the book, I would recommend you to read it. You know that in the law, there is a theory saying that the norm, the rule, is fundamentally an hypothetical judgment concerning the commanding of a sanction. So first you have a sanction, and then you have the rule. So in order to have a rule, you should identify that what is a sanction. Now, and the sanction is identified as a prejudice, some evil is inflicted upon the person. Now, Hart makes this example. Also, Oda Weinberger, before Hart, I must say, made this example in a previous article in the 50s. Oda Weinberger was a logician and law scholar. I had the privilege of being his student in Austria, in Graz. Anyway, suppose you have to pay your tax. So you have an income, and every year, unfortunately, we have to pay a percentage of the income. In Italy, I pay nearly 50% my income. I'm not having a huge income, but this is our taxation in Italy, which is not the taxation you have in Estonia, I suppose. Well, we have progressive taxation. Of course, I wouldn't like to pay this taxation. Because why? Because taxation is evil. So it's a very big sacrifice I have to make. Nearly half of my income goes to the state. Okay, big income, big sacrifice. Now, if I believe that a sanction is a sacrifice imposed by me from the state, I should identify this as a sanction. Now, but is this a sanction? So the rule is, if you are an income of, I don't know, beyond 40,000 euros, you will pay 35% of your income. You will pay 35% the combining sanction or not? According to Kelsen, it should be. So Kelsen is not able, once you put this, the focus on the previous identification sanction as such, as an evil, you are not able to identify, to distinguish between the rule imposing you to pay taxes from whatever other rule, in the usual rule, because the rule is imposing you a sanction. And the sanction is an economic or whatever sacrifice on your resources. Now, in the case, and this is, of course, a demonstration that Kelsen's theory of norm doesn't work. Okay, and we cannot elaborate about this. Let's have this. Let's go to the Brownsword proposal. If I have an algorithm, and for instance, I cannot be able, through the algorithm, once I don't pay the car tax, I know that in Estonia you are introducing a car tax. It's quite controversial now, I know that. You didn't have car taxes. We have car taxes in Italy. In Italy we have all possible taxes. But suppose there is an algorithm that once you don't pay your car tax within the deadlines, let's say the 31st of January each year, you enter into a car, you put the key, and the car doesn't move. Now, what you do? What is this? It's a big, of course, you cannot move. But the problem is that you don't have enough information whether this is a really problem in the car. Perhaps you cannot. Oil, gasoline might be insufficient for your car to move, or gasoline was put, water in the gasoline. It happens in Italy sometimes. I suppose in Britain you are very serious, you are very honest, you don't have such problems. Or just your car has a problem, I don't know, the electricity and so on, and doesn't move, start. So you are not able to identify, you don't have information enough that you have done something wrong. Okay? Because you are just immobilized. So what is the difference between, because the algorithm stops you, but should signal you that you have done something wrong. Mm. The algorithm as such is not able to signal that you have been something wrong. Mm. Something wrong is only semantically addressed to the addressee. So it's only by propositions. It's only one proposition, which is not an algorithm. A proposition has a semantic content. The algorithm has no semantic content. And the semantic content signals, this is wrong, this is not wrong, this is good, this is... So in the case Professor Brownsword proposes, where there is no semantic content, it's more or less the evil. Kelsen, think about it, is not able to give the normative information. So his theory collapses. So this is one claim. Hmm. And then there is a second claim to make Professor Brownsword's theory collapsing. Very interesting. These are the two claims. Hmm. The other claim is that the rules are not only obligatory rules, you know, Hart again. Hart, there are two kinds of rules, primary rules and secondary rules. Primary rules, rules of obligations. Okay, the case mentioned by Professor Brownsword are always rules of obligation. But we don't have only rules of obligation in the law. We have a lot of rules of power, adjudication, and change. So you know that according to Hart, we have kind of meta rules, secondary rules, rules of change, rules for that, for instance, allow a judge to give a judgment. They are empowering rules, not constraining rules. The rules of judgment, rules of change, for instance, the competence legislators have, but not only legislators. Think, for instance, of a contract. A contract somehow could be seen as a rule of change. You change a previous legal situation. And then, what is the third way? There are third rule. Sorry, the recognition, which is the more controversial. I don't want to speak about because it's, but it's a bit constitutional rules. So of course, constitutional rules could not be algorithms. So since the rules are not only, not mostly, not fundamentally, I would say, not principally within the law, constraining rules, but are empowering rules. And since algorithms cannot be translated as empowering devices, they don't empower anything, they are constraining. Professor Brownsword example. Again, the idea that algorithms can replace law collapses. So I would give you
I'd like a word as well.
You would say something.
But
yeah, please.
But Roger first, please.
Roger first, please.
Okay. Well, thank you very much. Thanks for the.
This is the question.
The questions. Yeah. I'm sorry. I wasn't expecting to have to defend Law 3.0 here today, and but I will say a couple of things about this. But I wanted also to pick this up to what Gerald's just said in his talk. I mean, if the argument is that the thesis in Law 3.0 or the theory collapses, if that's the question, that there's a way of this collapsing. What kind of theory or thesis am I actually presenting in Law 3.0? Now, I see this as a sketch of three ideal typical mindsets of what's involved in thinking like a lawyer. Okay, when we say, in law schools, what we're about is trying to train young people to think like lawyers. My question is, how do you conceive of someone thinking like a lawyer? What kind of reasoning is involved in this? Okay, and the Law 1.0 mindset is of someone who is focused on the doctrine or on doctrinal coherence in the way that and that's basically what most law schools have been in the business of trying to train their students to do. To work with the legal materials, to understand where they're clear, where they're contestable, all that kind of stuff, and try to aspire for coherence in the way that it all comes together as a body of doctrine. That's one mindset, and it equips you to advise on the legal position on a particular set of facts. Okay. And it's argumentative and it's normative in just the way that Gerald said. That's characteristic. Now, when we come to Law 2.0, that's also normative, but now we're talking about a regulatory mindset, which is typically politicians who are driven by policy. And if you say, well, where do we find that kind of mindset? I say, just go to Brussels, because the EU's thinking is characteristically regulatory in precisely that way. And lawyers are not being trained to think like that because we think there's, in Law 1.0 world, we think there's a huge difference between law and politics. We think, like Ronald Dworkin says, it's not for courts to decide on the basis of policy. There's principle, not policy. But policy becomes the focal thing and instrumental reasoning in Law 2.0. Now, in Law 3.0, where we're beginning to use tools to channel and guide people in the way that they behave to do the channeling job, that's still regulatory in that we're trying to do this in a way that will serve our policies. But the more we rely on the tools, the more we shift the frame from the normative to a non-normative frame where it's not a matter of what one ought or ought not to do, but a matter of what we can and cannot do. And some of the things that Massimo has just said here, I think, exemplify this, that if the car won't start, the car won't start. Now, you might try to reverse engineer from this a view about what the normative background is, that there's a kind of, it's like, suppose you're playing chess on a computer, and the software will not allow you to make a move as you are playing that game. It will not allow you to make a move that is not permitted by the background rules of chess. So as a player, your experience is, oh, I can't move the bishop in, horizontally or vertically. I have to move it only in, that's all I can do. The whole mindset in that world is restricted to what can and cannot be done. And you might, as I say, in the case of chess, you might be able to reverse engineer what the rules are. They are still there in a background way. But if you're an out-and-out technological solutionist way of thinking, you are just trying to create a world where some things are possible and other things are not possible. And the experience of people in that world is entirely restricted to that. It's a non-normative experience. Now, the second thing is that in almost all my writing, going back to something I wrote in the Berkeley Law and Technology Journal years ago, I've been trying to say technological management and that kind of non-normative governance is a very bad idea. I think because I think we lose in that world in the way that Gerald said. All sorts of things which we value in our human interactions, in our humanity. I think Gerald mentioned just briefly the idea of trust. But I mean, the concept of trust in human relationships is quite different to the way we understand trust in a mechanical world.
Indeed.
And in fact, there's, William's interested in this too, I know, but there's a wholesale exportation of language from the world of laws governance to a world that will be governed by AI or other technologies. When I was on the Royal Society Working Party on Machine Learning, which was a working party entirely composed of data scientists and me, so my role was to give answers to questions like, well, what would the data protection law say about this? But at one stage in our conversations, this question of how we understand explanation was discussed, because I was saying, exactly as Gerald said, look, there's a difference between explaining how the algorithm works, how the variables, what variables are, how they're weighted, and actually justifying the decision. It's different. And one of the data scientists said, oh, yes, that's right. But I think we're about to have a Copernican revolution in the way we understand explanation. I thought, well, thanks very much, but I don't want that. That's and in the same way, well, I could go on with trust, justice, any of the concepts that are really important in our human relationships. They get distorted and it's a kind of black hole. You worry about black boxes with AI, but it's a black hole into which this language disappears and comes out meaning something quite different. Very interesting indeed. But so I'm trying to present ideal types of what I think are distinctively different ways of thinking like a lawyer, different modes of governance. One mode of what is out and out normative, and the other is non-normative. And I think Gerald's right. I think that we're going to arrive in the next few years at a kind of consensus position where we do recognize the benefits that can be gained through using some AI, but it will always be, there'll always be human oversight where it really matters, and it'll be the devil will be in the detail. But we'll be trying to work through where we are happy with humans and AI working alongside one another in some way. I think there is a big difference between a world in which there are only certain options available to us and a world in which we are guided by normative standards. It's one other thing I would say finally, if I can, I've been very negative about technological management, saying, look, even if the technology steers you to doing what in the normative world you would say is the right thing to do, You can't claim any credit for doing that.
Right.
Yeah, you can't claim any credit. But, you know, because the reason you're doing this is not because you judge it to be the right thing to do, because it's the only thing you can do. You know, it's dystopian, this. But I want to say I'm worried in my own thinking about that I've overlooked the way in which technological management can actually enable. I mean, I've been thinking about technological management as constraining. You know, you present some kind of risk to me, okay, and we will technologically manage this environment so that you cannot do these things. We will preclude you doing things which would harm me. So that's the sort of model, okay? But what about technological management that doesn't come at it from that end, but instead focuses on the powers I have and enables me to neutralize or counteract these invasions of my rights or whatever, you know, that would otherwise occur. And you say, well, how could that possibly be? Well, let me give you one example. There's a case not so long ago where a woman complained that when she was playing on, in one of Meta's virtual environments, her avatar was being harassed and stalked by avatars that were operated by some other players who were doing this intentionally with a view to causing her distress, which it had caused. Okay. And you know, a law 1.0 response to this will be to say, oh, we need to have a rule that says you shouldn't be using your avatars to harass other avatars with a view to causing distress to the players, controlling that avatar. But what Meta introduced there was a law 3.0 response. They said, right, we'll change the software so that as a player, you are now able to set a protective space for your avatar, kind of like social distancing. You can impose that so that you won't be harassed, which will be like, well, you know, like we talk about privacy-enhancing technologies where the setting in the device gives you the option to choose a setting that will protect you against what would otherwise be invasions of your privacy. Now, I mean, I don't imagine there are too many cases where we can do this, but enabling technologies, you know, for lawyers are hugely important. When I was an undergraduate, there were two big problems. One was there weren't enough seats in the law library, and the other was there weren't enough books that were relevant for our classes. You know, you'd have 100 students chasing a copy of the Criminal Law Review where there was an article. I mean, it led to some really bad practices. You know, people, well, I won't tell you what the bad practices were, but leave it to your imagination. There were lots of bad practice around. People who found the materials, you know, would not return them to the right place in the library. You'd find when you got into the Criminal Law Review that the article had been razed out. There's some terrible things going on. Now, if at that stage we had a law 1.0 mindset, we'd say, right, we need to stiffen up the rules in the law library about the way students use and, you know, the sanctions and all the rest of it. A law 3.0 response there might be about trying to stop people doing this, but you could also have an enabling sort of response, which, would you believe it, is what we have now, although not intentionally so, because, you know, well, first of all, photocopiers, and then digital law comes along, so that, you know, we have solved the problem of a scarce resource. Yeah, we can all access the law at any time we want, and it doesn't matter whether hundreds of people are accessing the same article. So the technology has been enabling here. I mean, this was serendipity, it was fortuitous. It came along to solve a problem we had. But suppose people had that problem-solving mindset already, and we're looking at technologies like in COVID, you know, where you say, we got a problem here. And the answer is not rules about confinement or what, but in the end, it's vaccines. So we want to invest heavily in that. I think that there is something to be said for technological management where it's enabling, but I'm not sure whether there's a downside to that as well. Okay.
I know that we are late, but we know this is a very fundamental point. We are in the center of the discussion. And since I do not agree with Professor Brownsword at all, I would propose to, this is a very fundamental question which we are raising now. And how in the way you propose you reinterpret your theory, you are softening your theory and making your theory, sorry to less interesting, because when you don't speak of mindset, you know, okay, mindset, but it's not law. Mindset, then you shouldn't title law 3.0, but you should title law mindset 3.0, which is a completely different story. And, you know, in these terms, we have always had mindset 1, mindset 2, and mindset 3, even in the Roman law. Because in the Roman law, you had the general norms, then you had the decreta of the very specific norms of the Senate, and then you have, of course, prisons or chains. Because if you put a chain is technology. They had the huge technology. They put people in chain, and that was law 3.0. Okay? Where is... do I interpret you well?
Yes, it's just that we have a range of technologies today that's radically different. This is the question. Well, we were very much anticipated in the Roman law, so we should study Roman law instead of going to algorithms. Shouldn't we know? What do you think? There's been technological management's been around for a long time.
So if it's a technological management your problem, then we should read instead of Roger Brownsword. You know, I have the greatest admiration towards your work. But we speak of technology, I will go and read Heidegger, or I will go and read Hans Jonas. They are much more informative, much more elaborate, and much bigger thinking about technology. So the question of techne, what's the technology? We know technology is changing the world, the atomic bomb, and so on and so on. So, and you know that Heidegger told us in a very famous interview to the Spiegel, only a God can save us. I'm more or less of the same opinion. We are in a situation in the world where technology is so strong, it can do whatever, can destroy us completely, control us completely, that only a God or only law, but not law 3.0, just law can save us.
So let me interject here, please.
Please.
Because I do think that you have made the case for law too easily. That is our, mind you, my lecture just 20 minutes ago wasn't altogether favorable to the development of law, or at least I put as clearly as I could what I thought some of the key losses are. But it's not true that what our legal system now tries to do in terms of not only rules of obligation and so requirements, but power conferring things. It's not true that technology can't do it. In fact, it can. If you think seriously about what are now proposed as particularized, personalized directives or mandates, it is possible for the same thing to be achieved. So power conferring rules are important for what? Oh, for example, allowing us to decide on a partner for marriage. And so establish a relationship recognized by law in this way. It's a power conferring rule. Another power conferring rule is part of our understanding of property, because on that understanding we have the power to decide how our current resources are distributed after death. Just two examples, all right? Law can do that. I mean, sorry, technology over some time can do that, because what it can do is actually create a directive or a mandate or, in fact, a dictate that produces exactly the results that you would have done choosing your marriage partner and distributing your money.
How?
By simply fully understanding all your preferences, your wants, all those things put together.
And you think there is such a machine?
No, listen to me. Listen to me. What it can do is produce exactly the result. You have married just the person, you have distributed the money just to the people you want, and it can do it automatically. Now, what's problematic about that is not that it doesn't have a way of exercising what, or doing, resulting in the kind of thing power conferring rules can do. It's that it doesn't provide people choices, doesn't provide people opportunities for exercising their agency. It's not that it's not a power conferring rule, it's that it does it in a way that doesn't do what a power conferring rule is meant to do. And so the problem here is not with not being able to do that kind of thing. It's that it fails to find a place for normativity, for human agency, for exercising that agency with responsibility. It's not enough that my property goes to just the people I want. It's that I get to do it.
You just confuse power in material terms and power in terms of normative terms.
No, that's just what I said.
No, this is a huge confusion you are doing. And it's when, for instance, there is a rule saying that the President of the Republic can appoint the President of the government, the Prime Minister. In the case of Professor Amato, he was appointed twice by our President of the Republic, two different Presidents of the Republic. The power is a power that is, first of all, it's the power, of course, in material terms, he might have this power. He says, okay, I come in Quirinale, so the place of, I say, I want to have Professor Amato Prime Minister, but I don't have the competence in physical terms. I'm capable to do that, but I don't have the normative qualifications to do this.
But technology can do all of that. The problem is the technology can do all of that. The problem is that it can't do it in such a way as that gives you power to do it, gives you agency.
The normative qualification, the technology, please, I don't understand. What normative qualification, the technology, what does it mean? What does it mean, the normative
so you can build that into our technology as well. It
so
just
you
has
mean
to be,
that the status, a normative status, can be the product of technology, a normative status.
But you make it too easy. You make it too easy.
You make too easy, but you make too ununderstandable.
No. The technology is so resourceful that it can do most of the stuff that we think now law can do. The problem is it doesn't do it in the way we want it to do. It doesn't provide us with the capacity to make judgments, and so that the results are not the results of what I happen to prefer, but what I choose to do. Those things are left out because normativity is left out. It's not the objective. You can build all the other things into technology, or they can sometimes.
I believe that the world is not only empirical. So I come from a neo-Kantian product, which is actually the philosophy, what is the great shift in philosophy. So I believe that there are different elements in the world. There are the natural world, then there is the social world. And what is the rules for the natural world are not the rules for the social world. The social world is completely, there is an emergence in the social world, which is symbolic, normative, and so on. Technology is only capable of producing things in the natural world.
Yeah, I understand.
In the social world, there is no possible technology producing things. So if this is so, and this is my ontological assumption, what you say doesn't work. Okay? But okay.
I accept all of that. I'm a neo-Kantian too.
All right.
That's not the issue.
You know, we are too late. Thank you very much for your attention. And we resume, let's say, in 1 hour and 15 minutes. So now is, let's say, 10 minutes to 3, okay? 10 minutes to 3.
Very good. Thank you.